in association with Institution Innovation Council. We are extremely happy to welcome Rohini Nair ma'am as our resource speaker. She is the co-founder and partner of cooperative and private equity practice of a full-service national law firm A&B Legal. Apart from the professional background, she is also a trained Bharatanatyam dancer. Welcome, ma'am. I also welcome all the teachers and students for the session. We can start the session with the grace of God. I welcome Lakshmi Umesh for the prayer song.
ईश्वर चैतन्यं जीवामृतम् ई प्रपञ्चत्तिले स्नेहामृतं निरयते निरञ्जोगिरते मानवहृदय निलयलिङ्गम् ईश्वर चैतन्यं जीवामृतम् ई प्रपञ्चत्तिले स्नेहामृतम्.
Now I invite Anu Udayan for the welcome speech.
Good morning to all, esteemed resource person, respected teachers and all my dear friends. I'm Anu Udayan of 2nd BSc Mathematics, and I feel honored to welcome you all to this workshop on intellectual property rights and IP management for startups organized by the Department of Mathematics and Statistics in association with Institutions Innovation Council and IEBC. It's my pleasure to welcome our resource person, Ms. Rohini Nair, co-founder and partner of A&B Legal, a full-service national law firm. She's the key member of the startup cell of this firm. Her work in the area of technology has extended to legal and regulatory issues in the online domain, such as artificial intelligence, e-commerce, edtech, etc. She's an avid speaker at thousands of now industry. Once again, I welcome you all to this function. Thank you.
Thank you, Anu. Now I cordially welcome Rohini Nair ma'am for the session.
Very good morning to everyone, and it's a very good start for the morning. I mean, really kind of you guys to do that. And very good morning to the entire team of Teresa College. What I'm told is you guys are students who are maybe wanting to be entrepreneurs tomorrow, so you guys want to probably understand a little more about intellectual property rights, the various elements around it, and more specifically, of course, the law aspect, which basic idea is what I'll surely give you today. Because if the idea is to not really get into the details, that probably we could leave it for another session someday. But let's start off with maybe taking you through the basic aspects of intellectual property rights. But before that, what is IPR and why is it so important? Before I start off, since you guys knew that I'm going to be here taking a session, how about I ask you all, what do you guys know about intellectual property rights, and why is it so important? Can any one of you? Punishment I will not even ask your professors to maybe give you some sort of assignment to do at home. But would any one of you want to take it up? That why is it that we're discussing IPR today, and how is it important to us? Anybody? We have about 59 participants. I'm sure one of you can at least answer. Anybody?
Ma'am, it is very useful for one who is starting a business.
I'm sorry, come again. Say it again.
It's very useful for one who starts a new businesses or have new ideas.
Mm-hmm. Okay. So you have a new idea. So Maria comes up with an idea that fair enough. I want to do. I know this is my idea, and I know I want to probably take it forward. I want to commercialize it. I'm going to make some revenue out of it. Is that idea sufficient? Can you patent an idea? No, you can't. You can't patent an idea. So what do? Basis the idea, you come up with a solution, you come up with a product, you come up with something which is tangible, which you can, or intangible for that matter, but which you can sell. Correct? Now, when you are trying to sell that, you can't just sell it as is. Today, if I want to have a coffee, today I can relate to Starbucks. Why? Because Starbucks is a brand. I can relate to probably a Nescafe. Why? Because it's a brand. So that brand has been created. Therefore, tomorrow if I come up with a coffee which I think doesn't have a chicory mix, it's a pure coffee. That's not enough. I need to, in order to ensure that I sell that coffee in the market, in order to generate revenue and make the consumers realize that my coffee is something which is very unique, I will have to give it a brand value. That is one of the aspects of IPR. This I'm talking mainly from a perspective of maybe trademark here. Okay, but just to give you a brief about why is IPR so important in our lives. Okay, so thanks Maria for that. Let me just start with probably giving you a presentation that I had briefly prepared. I hope this is helpful for you guys. Is my screen visible to you guys?
Yes, ma'am.
Okay, perfect. Like I said, why is it important to protect your intellectual property, right? Be it around your product, your services, your solutions, whatever you call it. Now, tomorrow when you start a company, it's a startup, you will use a trade name, brand, logo, advertisements. You probably have some design to your product, a website for that matter, in order to create a distinct identity and sustain the market. It becomes very important for you to secure the IPR around such trade name, brand, logo, etc. So there are a couple of things that we're going to discuss, various types of IPR that we're going to be discussing here today, very briefly, of course. Now, when I talk about trademark protects your brand value and recognition, which we just discussed some time back, right? Copyright helps you protect the artistic work. It could be a melody, it could be a website theme, it could be some literary work that you probably come up with, for your company. Patents is usually for any kind of invention that you may have developed, right? So trademark, copyright, patents. This industrial designs is also that you can help you protect your design if at all you come up with, right? So as an organization, one should be very proactive in developing and protecting their IPR for one of many reasons being to generate a better goodwill for your company, for your product. Other thing is to protect its competitive advantage in the market. Also, it helps you use the IPR as a marketing edge. As and when you actually step into the market, it surely helps you give an edge, because if you think your product is unique, if you think your solutions are unique, then yes, by protecting your IPR around it, you are sort of able to get a marketing edge. To use the IPR as a potential revenue stream through licensing. Obviously, once you've developed a product, in all likelihood, you may want to go ahead and probably have franchising arrangements, licensing arrangements. That's a very common revenue generating streamline. Having said that, in order to enable you to license it, you need to have protected it yourself and have it owned in your name. If you don't have proprietary rights on it, how do you think you're going to be licensing it? Even if you license it, how are you going to ensure that you are the owner to it tomorrow? Therefore, it's important for you to ensure that you have protected your IPR around these things. Now, in my experience, I'll tell you, I run a startup cell, and more often I've seen startups come up with these unique ideas, which is, I mean, I must tell you, I'm sometimes mesmerized to even see those products and the solution. They actually understand the gaps which are there in the market, and they actually come up with solutions which can actually bridge those gaps. But unfortunately, the startup entrepreneurs are so focused on carrying out their business operations, on probably doing good, or probably improvising on their product. More often they miss out on sort of protecting their rights around what they have actually developed, right? Now, when that happens, you have probably scaled, but then tomorrow you don't know what infringement claims are at your doorstep, because you have to protect yourself from all quarters. You don't know what's going to come from where, and IP infringement claims is the last thing that you want really on your table, right? So therefore, and even for that matter, if you are intending to probably come up with a venture and go in for funding tomorrow, you probably seek investments from your investors. Your investors are going to be valuing your IP. Now, if your IP is unique, is what you believe it to be, then ideally the investor would expect you to have sort of taken all necessary steps to have protected your IP. Now, protecting your IP are by way of various means. One could be registering your IP with under the applicable legislation in India. Second could be by way of contracts, because in all likelihood you may be working on a product or a solution, but you may have a team who would work along with you. If they are your co-founders, then do you have a co-founder agreement in place which says, okay, five co-founders working together, the product belongs to the company? Is it written down anywhere? If you have employees tomorrow, if you have workers working for you, have you had a contract in place which says that fair enough, you are working for the company, whatever you've developed belongs to the company? Is it getting covered anywhere? Have you taken necessary measures to protect the IPR of the company? Is the question that the investor would ask. If the answer is negative, or if you have not taken adequate steps, then what happens is, unfortunately, your valuations take a hit. And in my experience, I have seen this more often than not. It's a sorry state of affair, but then what do you do? It's business at the end of the day, right? Trademark registration. Now let's talk about trademarks. We will touch base today on trademark, copyright, patents, and industrial designs, all of it. We will briefly run through all these 4 types of IP. Okay, post which, if you guys have any questions, happy to address them. Let me make it very clear, I'm not taking up the procedures that you need to follow, because that's very procedural, and that could be probably taken up another day. But since we have 1 hour, let's utilize it to understand the basics around it and why is it important. After these 4 IPs that we're going to discuss, we're also going to discuss about the various type of IP arrangements that you could probably consider as and when you have probably come up with an IP of your own, right? So yes, Trademark Act 1999. Now, trademark means any word, symbol, logo, slogan, packaging that identifies the goods or services of a particular source. Now, trademark definition under the Act is pretty simple to understand. It says a mark capable of being represented geographically, graphically, and which is capable of distinguishing the goods or services of one person from those of the other, and may include the shape of the goods, their packaging, and the combination of colors. Now, any startup, for example, your venture for that matter, needs to be cautious in selecting the name, brand, logo, domain name for that matter. You have to do proper due diligence before adopting a mark, because you need to figure out if there is anything similar in the market, because if there is, then ideally you should try and see to that you're not somewhere close to what exactly the similar one is, because you don't really want an infringement claim happening or a passing off claim, right? So generally ensure that you're not really going for a generic word, because a generic word cannot be passed off as a trademark. Having said that, I've made couple of applications for my clients whereby we've sort of come up with taglines which we get registered, and those tagline generally has those generic terms. But then to fight it out with the registry is like a challenge. We won quite a few matters. We had to project it to the registry. We had to justify why is the tagline so important to us. So we had to actually project as to where all have we used it till date, and the fact that how our customers relate to the tagline with my client's brand. So all that becomes slightly challenging. I'm not saying it's not doable. Yes, some cases the registry has outright refused as well. So just ensure you're not really using a generic word. Now in India, we follow a NIC classification of goods and services. We have 45 classes, whereby 1 to 34 is goods and 35 to 34 includes services. So if you are in the business of probably manufacturing or distributing goods, then yes, you have to identify the relevant classes under 1 to 34. If you are in the service sector, probably rendering consultancy services, etc., then you have to ideally go between 35 and 45 class. You have to identify which category do you fall in. Now, NIC classification, which I just mentioned, is recognized in majority of the countries, and making and therefore makes applying for trademarks internationally a streamlined process. Right now, having said that, trademarks do play a significant role. Whenever you're doing a business or thinking about starting a company, the first thing you must do is get the trademark, the brand registered, for the security of the trademark, and to maintain the quality of the product in the eyes of the consumer. Because ultimately, that's why you are in the market, right? So if you are thinking of selling your products globally in the future, then registering your mark is essential in all those countries you're planning to expand your business later on. There are two, when we're talking about IP, there are two things that you have to be wary of: infringement claims and passing of claims. This is a very, very a tricky point, a subject, which since we're discussing the intellectual property rights as a subject, this is very important. Now, what's an infringement? In the course of using a trademark, if at all, it is said to be infringing the rights of another company due to use of identical or similar or deceptively similar mark for marketing of allied goods and services. That's an infringement. That's termed as infringement. Now, what's a passing off? It's interesting, okay? The Trademark Act itself doesn't really have an explicit provision that specifically defines the term passing off. So therefore, we have to rely on common law judgments. Let the courts draw its meaning as to whether the infringement of a trademark done is in such a way that the mark is not deceptively similar to the existing trademark of the other company, but it is also capable of creating a confusion for the consumers, which ultimately results in damage to the business of the company. So two things. So infringement only talks about deceptively similar trademark, while passing off looks at two things: not only deceptively similar, but it is also capable of creating confusion in the minds of the consumer. Two things in passing off. If both the things are ticked off, then it's a passing off claim, right? Now, in case of infringement and passing off, what's the type of remedy that one may have? A statutory remedy under Section 29(1) of the Trademark Act. This is in case of infringement. In case of passing off, like I said, there's no section under the Trademark Act. Therefore, you go under common law remedy. Now, when the trademark has been registered by the owner and infringement happens, then it becomes a suit for infringement. But if the trademark has not been registered by the owner who's making such claims, then the infringement happens. It becomes a cause of, it becomes a case of passing off. So the person who's making a claim, depending on that, it would be determined whether it's an infringement claim or a passing off claim. So if you were to make a claim, an infringement claim against a person, saying, if I know what that mark that the other company is using is similar to what I have, if your mark is already registered and thereafter you're making that claim, then you make an infringement claim. But if you yourself have not really made an application to trademark your logo, brand name, whatever it is, and then you're making a claim against a particular person, then that would ideally become a passing of a claim, right? In case of infringement, the proof that the plaintiff has to show is the plaintiff is only required to show deceptive similarity, as there's a presumption of confusion. In case of passing off, apart from proving deceptive similarity, the plaintiff is also required to prove confusion in the minds of public and the likelihood of injury to the plaintiff's goodwill. Now that's challenging because more often than not, it's very difficult to prove. Therefore, it's easier to make an infringement claim because you're already a registered owner. You have proprietary rights to that particular IP, and thereafter you're making an infringement claim, right? Now, this is a brief about what infringement versus passing off. You'll come across these terms, so therefore I thought you should probably be aware of what these points are. In case of any infringement or a passing off claim, for that matter, the relief which a court may usually grant in a suit of infringement or passing off includes permanent or interim injunction, damages on account of profits, delivery of the infringing goods for destruction and cost of legal proceedings. It is very important for you to note that that the infringement of a trademark is also a cognizable offense, and therefore criminal proceedings can also be initiated against the infringer, right? Now, in the subject of IP, you usually have a concept of prior usage rights. What happens if you apply for a trademark application and get the trademark registration, but later on find out that someone else has been using the same mark since before you had filed? So what happens? Well, the principle of priority in adoption and use prevails over priority in registration. Okay, therefore, it is a well-accepted judicial principle that the rights of a prior user of a mark are kept on a higher pedestal over the proprietor of a registered trademark. Therefore, prior user's right will override those of a subsequent user, even though the subsequent user may have actually registered the trademark. Therefore, it's all the more important for you, before you make an application to the registry, while the registry will obviously do their bit about figuring out if there is any identical registered mark alone, but you yourself have to also do an informal search on whether there is anything similar or not, or deceptively similar. Because if there is, you will have to ensure that you are not sort of anywhere close to it. Therefore, you need to seek appropriate counsel from your attorneys in order to ensure that you're not going ahead with a mark which is anyway existing in the market, because it's not good for the one who's already there in the market with that particular mark, a similar mark, and it's not even good for you, because you don't really want the consumers to be confused about your product against the others. So what are the fundamental requirements for acknowledging a prior use? The use of a mark identical or nearly resembling the registered mark of a third person must be in relation to the goods and services for which the first mentioned mark is registered. So obviously, it cannot be any other product. It has to be similar product. It has to be the similar class of product. The use that we are trying to, if there's a prior usage claim, what you also have to see is, has it been a continuous use of the mark in India? And it cannot be very intermittently done. The trademark must be used by the proprietor in order to avail the protection. Lastly, the mark must have been used from a date prior to the use of the registered trademark. Only then you can obviously claim a prior usage uh, right. Now, over the years, we've seen that the filing process has been made streamlined. That's an online process. The duration has also been sort of reduced. In fact, there is a lot of subsidies in terms of the government fees. Also, there's some discounts which are available to MSMEs or DPIT registered, the registered startups that you have. If you have those kind of registrations, and you do get discounts on the government fees, so do keep it in mind. So what you should ideally do is, I always tell my clients about this. As and when you have identified a product or a solution for your business, and you are right there, and you think it's about time that you step in the market, get some traction in the market. Okay, obviously before you get some traction, see if the brand that you're trying to create is already there in the market. If you think it's unique, try and give it a different color, try and keep it unique. Once you've done that, approach your counsel, approach your attorneys in order to sort of register your IP around it, make the requisite applications, put it in the process, because while it is seamless, yes, but it takes about 6 to 8 months for you to register your trademark. And so it's a long drawn process, because you file it to the registry will then sort of come back with an examination report. If at all they're not really convinced, then you have to respond to that. Your attorneys will respond to that. Thereafter there'll be a hearing. Thereafter it will be, once the registry is convinced, it will be actually published in the journal. It will be open to objection for the next 3-4 months. And once and if there is no claim by any third party, thereafter there will be registration done. Your trademark will be registered. So it's a long drawn process. So the early you start, the better. Next is copyright. Now, copyright, of course, is governed by the Copyright Act 1957. Now, what are the main sources of Copyright Act? Like I said, the Copyright Act 1957, yes, supported by the Copyright Rules 98. Okay, there have been substantial amendments, in fact, carried out in the Act in the year 2012. Right now, India is also a member of the Berne Convention and the Universal Copyright Convention. In fact, the government of India has also passed the International Copyright Order 1999. According to this order, any work first published in any country that is a member of these conventions that I just mentioned is granted the same treatment as if it was first published in India. That's the beauty of this order, the International Copyright Order that the government of India came up with. Right? So now what kind of work can you probably protect by copyright? Original literary, dramatic, musical, artistic work, cinematography work, sound recordings. These are basically broad headings. There are subcategories as well. But these are the broad headings under which you can probably file for the copyright. Now, what is it that is required in order to qualify a work for copyright protection under the Act? Any work which falls under these 3 categories that I just mentioned, obviously qualifies for a copyright protection. But the work sought to be protected must surely be original. However, it is not necessary that the work should have some original thought or idea to it. The law is only concerned that the originality of the expression of thought, which is important. If you have that, then yes, you qualify for copyright protection, right? Now, what rights does a copyright grant to the right holder? This is important for you to know. A copyright grants protection to the creator of the work, right, for the work, and prevents such work from being copied or reproduced without their consent. Generally we are under the assumption that a copyright could be as long as I'm alive. If I have created something and it's my own this thing, it's going to be there as long as I'm alive. Now there's a difference there, because it's generally 60 years from the date of the work which is published. However, in case of a literary, dramatic, musical, or artistic work, it's interesting to know that the duration of the copyright expires 60 years from the end of the calendar year in which the author dies. I mean, that's the duration of which the copyright is actually the copyright protection is existing. Okay. Now, who was the first owner of a copyright work? In case of trademark, we saw the prior usage concept, right? As a general rule under the Copyright Act, a copyright to any work vests in the person who created such work. So the moment you come up with a work, you come up with a work which is probably open to copyright protection, then you are the owner to it. That's the general principle. However, if in case of a work made during the course of employment or under contract of service or apprenticeship, then it is understood that the employer shall, in the absence of a contract to be otherwise, to the contrary, will be the first owner. So simply put, that if you are starting off tomorrow and if you were to sort of engage somebody to come up with a work, idea being, if there's a contract between the both of you, that okay, fine, you're working for me, you're going to create some work for me, then ideally you are the one who is the owner to the work and not the person actually creating it, because there is an employer-employee relationship that we have sort of established there. So it's important, all the more important, for you to have contracts in place with your employees or anybody who's working for you in developing such kind of work. Now, can you register a copyright? Next question. If so, what are the benefits of such registration and what other steps can you take to help you bring an infringement claim? These are basically some sort of key questions I thought is important for us to address it on this forum today, so that you know what can you do in case you have such work that you have probably created and what should you do next. Under Indian laws, registration is not a prerequisite for acquiring a copyright in a work. Please understand, it's not mandatory at all. People come to me with their works and what, I want to actually copyright it. But why do you want to copyright it? Is the question that you have to ask yourself. A copyright in a work is created when the work is created and given a material form, provided it's obviously original. We just discussed, right, what are the requisites for a copyright protection. The requisites for copyright protection did not mention that registration is mandatory. It did not say that. It only said it has to be original and it has to fall within those 4 categories that we just discussed. It has to be one of the works plus originality. That's all. It doesn't say you have to register your copyright. However, the Act provides a procedure for copyright registration. For whatever it's worth, you can go ahead. If that gives you comfort, go ahead and do it. Such registration does not confer any special right or privileges with respect to the registered copyright work. It is, however, suggested that the owner of such original work register it as a certificate of registration of copyright, and the entries made on the register serves as a prima facie evidence to your ownership. Therefore, if you come up with some literary work, if you come up with a script, a movie script, there are these associations with which you have to actually, sort of register your work. These are these autonomous bodies which are in existence, whereby you can sort of ensure that your work is protected and there's nobody else who is actually trying to replicate it. That's a brief about what patents copyrights look like. And so just one thing I have to tell you is, in case you guys come with a software tomorrow, I think we can discuss this. In case you come with a software tomorrow, a SaaS solution, or all of that, it is not important for you to, in fact, go ahead and register your software, because the moment you code, you come up with those coding and you come up with those software, that software, the moment you develop it, it's yours. And unfortunately, there are some cases where we've seen that while we try and apply for you make an application to register your software, you have to sort of give away your source code to the registry in order to enable them to understand the originality of the software. Now, when that happens, and there are some cases, then your sort of originality sort of compromised, and it's not a good place to be. Therefore, it's not important for you to register your software. Having said that, if you have taken help of your employees or IT consultants or your friends, whoever, to develop that software, then yes, you have to have adequate documents in place to project, to establish that the software so developed was for the company and the IP around it belongs to the company. Therefore, tomorrow, if that person who's worked for you on that particular software develops something similar, then tomorrow you can flash that agreement and say, you agreed that this belongs to me. How did you do it? You can probably file a suit against him. That you can do. But if you don't have a contract in place, it becomes very difficult for you to establish the relationship and the commercial understanding. Next is the patents, right? Now, patents is very technical in nature, so I'm not going to be really, taking you through the entire subject. I'm sure you guys may have already come across patents as a subject. We'll just briefly run through it. Patents in general, means a monopoly given to the inventor on his invention to commercialize that invention in the market. So there is a definition to invention, given under the Patent Act. I'm sure you guys must have come across that. It includes any new and useful art, process, method, or manner of manufacture, machine, apparatus, or other article, substance produced by manufacturer, and includes any new and useful improvement to any of them, right? The definition of the word invention in Patent Act includes new product as well as new process. It's very important for you to note that. Therefore, a patent can be applied for the product as well as the process, which is new, involving inventive steps and capable of industrial application. Hence, it is patentable in India. Now, before you file for an application for grant of patent, you need to know what is not patentable. Like I said, idea not patentable. You cannot just say, okay, fine, that was my idea, so it's unique to me. No, it's proprietary to me. No, it is not. You have to take this idea further, commercialize that idea further, go ahead and develop something basis that particular idea, and thereafter establish your proprietary rights around that particular product or service. So there are some inventions which are not patentable, which is frivolous, obvious, contrary to the well-established natural laws, contrary to law, morality, injurious to public health, a mere discovery of a scientific principle, or formulation of an abstract theory, a substance obtained by a mere admixture resulting only in the aggregation of properties of the components thereof, a method of agriculture or horticulture, inventions relating to atomic energy. All these are not patentable. To be very honest, it's not patentable. So infringement of a patent consists of unauthorized making, importing, using, offering for sale, or selling any patented inventions within India. Now, if you recall, we discussed, in case of infringement of a trademark, you can also initiate criminal proceedings. If you recall, we discussed. Under the Patent Act, only a civil action can be initiated in the court of law and no criminal proceedings. And accordingly, the reliefs which a court can usually grant is permanent interim injunction, damage on account of profit, the same that we just discussed. So the reliefs remain the same, but the kind of proceedings that you can take out is different. It is also important for you to note that patent infringement proceedings can only be initiated after a grant of patent in India, but may include a claim retrospectively from the date of publication of the application for grant of patent. This is not the same in case of trademark, if you recall, right? Industrial designs. Now, designs as such is governed by the Design Act 2000. What does the term design mean? It means only the feature of a shape, configuration, pattern, ornament, or a composition of lines or colors applied to any article in multidimensional form, by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. Therefore, if you can see it, if you can feel it, and it's tangible enough, and it's identifiable, such shape, design, whatever, it's yes, you do fall under the Industrial Design Act. Now, what it does not include is any mode or principle of construction or anything which is in substance or a mere mechanical device, and does not include any trademark as defined under the Trademark Act, right? Now, the owner of a registered design right may exclusively work on a registered design or any design similar to it. If a third-party manufacturer manufactures or sells the registered design or any similar design for commercial purposes, and if the third party itself is not licensed to do so by the owner of the registered design, such activity constitutes a design right infringement. Like, we discussed earlier what infringement means, right? So obviously you need to have the right to sort of license it further. Only then you can do it. Otherwise, it's an infringement. The scope of a design rights extends to not only the registered design, but to any similar design. Similarity of the design, whether it is similar or not, is an issue for determination of design infringement. Now, what are the essentials? We discussed what are the essentials of a trademark protection. We discussed what are the essentials for protecting a copyright. We discussed what is the essentials for protecting a patent around a particular invention. Accordingly, what are the essential requirements for a design for protection from design infringement in India? There are three things. One is, of course, the design should be original or new, for that matter. A design should have not been previously disclosed in public. It should not be in public domain. A design should be significantly distinguished from the other known designs or combination. If all these criteria are met, then yes, you can protect your design around this particular act. The total period of validity of registration of an industrial design under the Indian Design Act 2000 is 15 years. If you recall, we discussed 60 years in case of copyright. In case of industrial design, it's 15 years. The Indian Design Act 2000 only provides for civil remedies, just like patents, if you recall. In case of trademark, we also had criminal proceeding that we could initiate in case of infringement claims. An action for infringement of design can only be initiated after registration of design. If you recall, in case of trademark, we discussed, I can still file a passing of claim if I think there's somebody else who's using something similar to mine, even if I'm not registered, because then that becomes a passing of claim, if you recall, correct? So that's the beauty of how the statutes have been sort of structured. And you need to be aware of your rights. Just by protecting your IP around your product or solution is not sufficient. You also need to be aware as to what cause of action can you take, against any infringement tomorrow. So you have to be there in the market. You have to also approach. You have to always take a defensive approach. You have to be always prepared in the sense that once you've protected your IP, be aware of any similar mark, any similar product that comes in the market. See how it is, and if at all you think there's something similar to what you already have, then it's about time that you approach your counsels and sort of seek necessary steps to protect your IP. Right. So that's about industrial design. So we've discussed trademark, we've discussed copyright, we've discussed patents, we've discussed industrial designs. Now let's talk about a couple of arrangements that you could probably consider if you already have a unique IP in place, right? One, of course, is assignment. The other one is co-ownership. Now let's discuss co-ownership first. What happens is, generally, if you have come up with some unique solution, and if you think there's somebody who can actually add value to it, so then you collaborate, right? Now, once you collaborate, there's one kind of an arrangement where it happens that both the parties get their respective IPs on the table. Okay, while they will obviously own their respective IPs, they will own the respective IPs to their products, but anything which is co-developed by both will be co-owned by both the parties who are entering into this arrangement. Idea being that if something has been developed jointly, then of course both the parties have ownership to it, which means that if you want to enter into a licensing arrangement tomorrow, one party cannot just go ahead and just license out the co-owned IPR. It will obviously have to take consent from the other. Now, this kind of an arrangement, usually there are these commercial aspects around it. What you need to ensure is how long is this particular arrangement going to be for? Because sometimes, more often in fact, actually, this happens in case of a JV, joint venture arrangement, or a technical collaboration agreement, whereby we are saying, you know what, we are going to be working together for next number of years, probably 5 years, 10 years. So 10 years, we're together. Whatever we develop together is going to be co-owned by the both of us. So obviously, any party cannot just unilaterally go ahead and decide things for the particular co-developed IP. They'll have to mutually agree on what can be done and what should be done, right? Having said that, what happens? What is usually not addressed is that what happens after 10 years? The tenure is 10 years. What happens after 10 years? Who takes it away with them? Who owns it? Because the arrangement is over, 10 years is over. Then what do? Therefore, you need to have a mechanism in place in the contract, built in the contract, to say, okay, fine, what's going to happen? How is it going to function? Who's going to own it? Who's going to get revenue out of it? All of that needs to be discussed. Of course, now, if the co-owned IP is commercialized further, then yes, it usually so happens that both the parties are actually entitled to certain revenues equally in whatever ratio it is. So that's something which is important under the co-ownership of IPR subject. In case of assignment of IPR, what happens is that in case you are, in case there is an arrangement whereby, there's a next party who's developed an intellectual property which is worth, registering as a trademark, copyright, patent, whatever it is. Then arrangement being that you've developed it fair enough, but I would like to own it. And the other party is agreeing to it. So there's assignment of IP, transfer of IP from one party to the other. Now, the assignment could be in various forms. It could be in part, it could be in whole, it could be for a specific duration, or it could be for perpetuity. It could be any one of them. You could decide, right? Or a combination of two. Now, when that happens, all this needs to be discussed. And while you may have had an oral arrangement, but it's very important for you to put it in paper, because we have seen so many suits pending in the courts whereby these things have not been crystallized in the contract. Therefore, it's very, very important for one to have exhaustive, comprehensive agreements in place in case you're looking at licensing, in case you're looking at assigning, if you're looking at co-developing of IP, all that, if you're looking at, then it's very, very important to have a robust contract in place to sort of cover yourself. Now, other thing is, more often we see, it's very common now that, these companies in India, in fact, I've seen quite a few startups in Kerala as well, which have, which has a US arm, whereby the US company becomes the parent company of the Indian subsidiary. Now, when that happens, ideally the IP has been developed in India by the Indian founders like you. Once it is developed, the idea of setting up the entity in the US or any other jurisdiction is sort of to get traction from the investors, because they prefer investing in a foreign entity as against an Indian entity. When that happens, set up an entity abroad. With that happening, the investor is not going to put money in a shell company. So what happens is the IP also gets flipped to the US. So the IP also gets assigned to the US entity, and thereafter, because the labor is cheap in India, what generally happens is the back-end work actually is done by the Indian entity employees, and the US entity sort of bills, because obviously dollar billing is, you get more money, right? You can generate more revenue there. So the investors are interested in seeing more revenues in the US company, and they want the IP to be held there, because then that entity in which they put money has some value. Okay, Now, when that happens, if the Indian entity has to actually carry out the operations as such, it needs to have the authority and the right to use the IP. That's when we talk about the licensing arrangement between that entity and the Indian entity. So you see here, we have seen two set of arrangements here. One is the assignment, second is the licensing. We saw both between the two entities, and it's important. And when you look at this kind of an arrangement, you also have to take a look at the transfer pricing guidelines applicable in India, because it's a related party. Therefore, it has to be at arm's length. So that's a different subject altogether. It's a tax-related aspect. But yeah, what I'm trying to say is there are different ways and means you can actually have commercial arrangements pertaining to an IP, and one should be aware of it. Now, a brief of what we discussed, what you need to do tomorrow once you guys graduate, and good luck to you guys. And once you guys are wanting to start your own venture, and I hope that you guys do. Whoever has an entrepreneurial spirit, I'm sure you guys can do that. Identify your venture, the nature and the area in which you want to actually operate. Area in the sense, the sector that you want to target, right? Now, identify the intellectual property rights applicable to your startup. Once obviously you sort of developed your venture, you know what you want to do, and you sort of created your product, solution, whatever it's, identify in which class will it fall, trademark, copyright, patent. Now that you know what all that means, identify. Once you've identified, you have to get in touch with your IPR professional, lawyer. Please do not go in for these online portals which actually give you these online assistance. I mean, I'm not a very big fan of it, okay, but I leave it to you. That's your call. But get in touch with an IPR professional, attorney, lawyer, whatever you think, consultant, and get the process started. Get your IPR compliance in place, get all that registered. And as and when you think you're wanting to commercialize your IP, do something with your IP with another party, have robust agreements with them in place. Basically, do whatever you can to protect your IP, because that's the key to your business, and that's going to be the driving force for your company. And in case you're looking at funding tomorrow, like I said, your IP has a big role to play in your venture. I think I can't be emphasizing more than this, but yeah, this is what I had to say about IP. If you guys have any questions for me, please shoot. I'll be happy to answer. Nobody has any questions for me? Or you guys have not had your coffee this morning?
Hello. Hello, ma'am.
Yes.
I have a question.
Yes, please.
Ma'am, how can we file a patent?
How can you file a patent? In the sense, I'm sorry, I didn't quite get your question. Are you asking me which form to file?
Yeah, ma'am.
Like I said, Resya, right? Like I said, we haven't really touched base upon the entire process, the procedure. I think that's something which can probably take up for another day. It's a long drawn process. In case of patents, in fact, it's a very long drawn process. There are a couple of applications along with the entire workflow that you have to sort of submit with them in order for the registry to the patent offices to actually see to it that your the invention that you're claiming to be proprietary and original is, you have to establish the originality, and therefore there are a lot of things that you have to actually submit along with your forms. In fact, on the contrary, patents is a long drawn process more than trademark and copyright. So I think we can take it up another day.
Okay, ma'am, sure.
Hello, ma'am.
Yes,
I
yes.
So a question. What do legally and duplicate outlook of my product, which is already existing in market?
Sorry, I am unable to hear you. If somebody can repeat that for me.
What to do legally if a new brand duplicates outlook of my product which is already existing in market.
Right. So what I understand is if you are already there in the market with your product, correct, and you have sort of branded your product and you have filed for an IP, you've protected your IP by registering your IP around it. If after you've come in the market and registered your IP, if somebody else comes in the market, what is it that you're supposed to do? What are your what is it? What are the steps that you can do? Is that your question? Is that your question?
Yes, ma'am.
Now, right. So like we discussed, right? Infringement against versus passing off. You send a cease and desist notice to the other side saying, fine, you know what, this is what it is. I'm already there in the market. Mine is registered mark. Yours is deceptively similar and it's causing confusion in the minds of the public. Therefore, you are called upon to stop using the mark. That's how you send out a legal notice to them through your attorneys, and thereafter see how things go. Because if obviously, more often, if at all it is understood and sense prevails, then and the other side obviously stops using the mark, or they obviously recommend, fair enough, and if you claim it to be yours, and if it's yours, fair enough, they actually propose a couple of other alternatives that we would be comfortable with. If you're comfortable, fair enough. If you say no, it's an absolute no, then you ask them to stop using it forthwith. Now, if that doesn't really happen, then you have to go to the High Court to file IP litigation against that particular company. That's your recourse under law.
Okay.
Thank you so much, ma'am. It was such an insightful session. I'm pretty sure that everyone in this meet has a lot to take back. Here's a small request. All of you, please switch on your cameras to take a screenshot. Everyone, please. Thank you all. Now I welcome Julia Brill for the vote of thanks.
Warm and pleasant good morning to one and all. On this pleasant occasion, on behalf of Theresin family, I'm glad to thank Ms. Rohini Nair. She's the one of the co-founder member and partner and also legally trained Bharatanatyam dancer. She has addressed a wide range of audience and conducted few quiet workshops, especially for stakeholders in the startup space on deal life circle. Her hard work, professional sincerity and ability has been appreciable by almost all the clients whom she has served. Once again, thank you, ma'am. To inspiring all the students, being a woman, we also came to know about our property rights, being a bold woman, how to start up our IP management. Thank you, ma'am, for inspiring all the young ladies with your knowledge of wisdom. I wholeheartedly thank Arsalam ma'am, our IIC faculty convener, for always supporting us through wonderful webinars and seminars. Thank you, ma'am. I also thank Susan ma'am for traveling throughout this meeting and guiding us. I like to thank each and everyone who worked behind this program. I extend my heartfelt gratitude to each and everyone. Thank you.
Thank you, Julia. The feedback form is given in the chat box. All of you, please fill it. With this, we are coming to end. I'm Maria Peter signing off. Thank you all for joining. Thank you.
Thank you very much. Bye bye, guys. Have a good day.